Good morning and welcome. I see that there's some nods, so I believe I can be heard. Welcome to this ELI webinar on business and human rights. And thanks, Katja, for getting us organized and setting all this up. It's an impressive work. My name is Jonas Grimheden. I work at the European Union Agency for Fundamental Rights based in Vienna. And we're involved in this project on business and human rights with ELI. And at the Fundamental Rights Agency, I work with business human rights among many other issues, but clearly this is one of my main tasks working on this project. And as you maybe know, the Fundamental Rights Agency is one of the many agencies that deals with various issues, but the only one that has a human rights, a fundamental rights mandate. So we advise the EU institutions and the member states on issues related to fundamental rights or human rights. I'm a co-rapporteur for this project together with Diana Wallis that maybe some of you listened to, saw in another webinar yesterday in this ELI conference. We would like in this group, in this panel today, to share our work through a couple of examples. We are dealing with 4 or 5 topics within sort of the business human rights field, and today we'll deal with 2 of them. We'll have 2 presenters coming from the project team, and we'll have 2 external, if you will, presenters that will give a bit of a wider perspective or maybe a bit more critical view on the work we've done or on the issues. There will be a possibility for Q&As in written form and I think also orally later on. And what I will do now is to briefly introduce the speakers just before they speak, one after the other. And I would then ask the speaker to stick to the agreed timeline. So first of all is Lise Smith. Apart from being a member of our group, she was leading on the extensive research that was commissioned by the European Commission on human rights due diligence. So I'd like to ask you, Lise, how can human rights due diligence actually help access to remedy, and maybe also what is human rights due diligence? Lise, please.
Thank you so much, Jonas, and thank you very much for the invitation to be here today. Yes, thank you so much for this question. So the concept of human rights due diligence originated from the UN Guiding Principles, Pillar 2, the corporate responsibility to respect, and it refers to the process whereby the company can identify, prevent, mitigate, and account for its actual or potential human rights impacts. And currently there are various movements at EU and at national member state level and elsewhere to introduce human rights due diligence as a mandatory obligation in one way or another, which I'm sure Robert McCorkadale will speak about shortly. And so for the purposes of discussing the link between human rights due diligence and access to remedy, which is what portion focuses on. It's important to remember that human rights due diligence as defined in the UN Guiding Principles is an ongoing and a context-specific process which allows for the prioritization of the most severe risks, and risks are measured, severity is measured with respect to the risks to the rights holders and not just the risks to the companies. And it also then requires a process that is commensurate to these risks. So in this way, human rights due diligence, as defined in the UNGPs, is actually similar to what we know from the civil law duty to exercise a reasonable care, which exists in tort law in some form in both civil and common law jurisdictions. So in this way, conceptually at least, human rights due diligence and remedy can be flip sides of the same coin, in that if there is a duty to exercise care not to harm third parties, then it is also natural or logical for those affected parties to be able to claim relief if the company would fail to meet this standard of care. However, that being said, human rights due diligence is a responsibility of companies, And judicial remedies is the responsibility of states in terms of international human rights law and also Pillar 3 of the UN Guiding Principles. And therefore, by simply introducing human rights due diligence as a corporate legal duty, it would not automatically lead to an avenue for judicial remedy. And so our European Commission study, which you mentioned, showed that the need for judicial remedy is one of the main reasons why stakeholders, in particular civil society, are supporting the introduction of mandatory human rights due diligence regulation. But remedy would have to be built into the regulation. For this reason, the first recommendation which we make of our two recommendations is that the EU mechanism would therefore need to require member states to ensure access for judicial remedy for breach of the duty or the standard of care. This can be done in various ways, whether in the implementing statute, whether it arises as a matter of course in the tort law system, but either way, it has to be ensured that the corporate duty should be understood to lead to a remedy. The second aspect, which we refer to in the recommendations, the second recommendation relates to grievance mechanisms. So in Pillar 2 of the UN Guiding Principles also refers to operational level grievance mechanisms, which can take place at company or sometimes industry level, as part of the corporate responsibility to respect human rights. Grievance mechanisms and stakeholder engagement more generally is central to undertaking human rights due diligence in practice. And they should be used for the identification of issues, addressing issues, remediation, and then also monitoring whether any of the actions taken are working. However, it's extremely important to remember that these company or industry level remediation mechanisms are not always appropriate or substitute for other remediation efforts, and they certainly cannot replace state-based judicial remedies. And so therefore, in our paper, the second recommendation is that any grievance mechanisms or stakeholder engagement processes that are built into the human rights due diligence duty, in whatever way that might be done in the regulation, cannot replace and should not replace independent state-based judicial mechanisms. I will stop there and look forward to hear what the other speakers have said. Thank you.
Thank you very much, Liz, and very good overview, very good group. I am saying, looking them straight into their eyes. The next speaker is unfortunately not a member of our research group, but he nevertheless agreed to join us here today. Robert McCorkdale has an impressive track record in academia and as a practitioner on issues such as business human rights. So, Robert, what lessons would you like to highlight or relevance for the European Union and human rights diligence? And how can that lead to improved access to remedy? What you can help us with, please.
Thank you so much, Jonas, for that generous introduction. Also, my thanks to Diana and others such as Duncan for their valuable ideas for this research and this discussion. Lisa, you've got an excellent paper there, and I agree with the recommendations, where I have some clarifications, because there's actually very little consideration to date of the link between human rights due diligence and access to remedy. Now, the reason for this is that human rights due diligence is an important tool for the regulation of business to prevent human rights impacts, and it does include some remediation elements by companies, but it is not by itself a remedy for victims. Now, I just want to clarify one point. We talk about human rights due diligence because that is a terminology used in the UN Guiding Principles and then in the OECD guidelines and in other documents. However, today the language is more often human rights and environmental due diligence. We see this in the French duty of vigilance law and most of the other proposals of legislation in other states, and of course by the European Commission itself. There's a report, as you all know, a study which has been led by Lisa, for which I was also a co-author, And it was very clear from that the direction in this area also is to include environmental impacts. And certainly my experience is many of the cases to date have been environmentally based with a human rights impact as well. Now, when I say that human rights due diligence by itself is not create a remedy for victims, the example I can give is the role of the national contact points under the OECD, when they require human rights and also environmental due diligence as part of, I think, a very good term they use of responsible business conduct. Because although they have been very good in terms of seeking remediation by companies for their actions, in only 2 cases, as far as I'm aware, since 2011, there's actually been a remedy directly for the victims. So that's an example where even though there may be human rights due diligence as a requirement, there's not a remedy for victims. And of course, where human rights and environmental due diligence is in legislation, it must also have liability, or else it's very hard to get any consequence. An example of that is the Modern Slavery Act in the United Kingdom. And in fact, some of the initial uncertainty and still to be determined of the Duty of Vigilance Act in France. I also want to clarify one other point. Although we tend to think of human rights and environmental due diligence as being about companies, it can also be about public bodies. For example, the Modern Slavery Act in Australia applies to public bodies. And I'd be quite encouraging of that application, not least because there's a range of public bodies such as export credit agencies, development finance agencies, which most states have, which are very active in supporting companies' activities, even though in those instances where the consequence may have human rights impacts. And I think if we make these public bodies also subject to human rights and environmental due diligence requirements through things such as public procurement, I think that could be a significant step forward in the broader protection. The other point I want to make is about when we talk about remedy, we need to be careful about whether the remedy gives a remedy to the victim. For example, in criminal law, the company might well be found to have acted in some way complicitly or to have some criminal consequence. But that does not automatically give a remedy to the victim. I mean, in France, of course, you can join the civil claim in some instances, but that's not the position in many other states. Similarly, if it's under administrative law, often there's a fine which a company has to pay. Once again, that does not give a remedy to the victim. I would also say the same in relation to the pressure maybe that there should be any new legislation should focus on directors' duties. I've looked at this quite carefully, and in all jurisdictions, with limited exceptions, an obligation on director is a relation to their duty to the company, not a remedy to the victim. Now, I therefore agree with Lisa's recommendation that you need a judicial civil remedy as being vital to human rights and environmental due diligence. But it by itself isn't always enough because there are procedural obstacles which are often in the way of civil remedies. For example, in a number of the cases, some of which I've been directly involved in, there are often a range of obstacles for the victims to be to even get the case to a court. And in most instances, of course, the court which we're dealing with is the court where the parent company is the one that is it's looked at direct liability. But there are significant issues. There's burdens of proof, access to companies' documents, which are usually not, and obviously the companies usually resist providing, and issues of costs. And also for the company itself, there are significant obstacles which they have to overcome in relation to these matters. For example, a succession of victims bringing claims. And in fact, I would add that as a link to the excellent paper there is on private international law, which Ilaria and Catherine are obviously going to talk about next. From my experience, Brussels I and Rome II, when linked together, are crucial in overcoming some of these litigation obstacles, of course, within the EU alone. Yet the courts are still very reluctant to use some of the exceptions that there are, such as public policy ones, because otherwise the determination of the possibility of remedies and the amount is by the law of where the incident occurred. And that may not always actually give sufficient remedy. Or the courts may use other means to say, listen, it's not in our jurisdiction, we're not going to consider it. And so I think there's an interesting development, and I see this in my work with the Business and Human Rights Treaty, of looking at the idea of a forum necessitatis approach. I just add that because I think we can't neglect the obstacles in getting remedies. I would also say, I think although judicial civil remedy, I completely agree with, is the core. If you like, it's the water in the bouquet of remedies. I think there are other forms which could be linked in, such as mediation. I say that because often that's a much quicker form of remedy and is closer to the ground for those victims involved. But the civil remedy then still has to be there as a backup. There's one additional element which, because Lisa didn't really have to deal with, but I would add is relevant to this, and that is having a human rights and environmental due diligence defence, where the company can rely on their actions, which they took to say they had done so reasonably to prevent civil liability. And I think there's an advantage in this, in considering this, because often in practical terms, it can assist the victim in a case because the company has to disclose the evidence to show what action they have taken, so they gain that information. But it also can incentivize companies to act, because my concern with some of the human rights and environmental due diligence legislation, it can become a tick box. It's a bit like in some of the legislation there is on health and safety. Basically, companies just go tick, 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 yes, of course, and don't even think about it. And I think that doesn't help prevention of the impact on victims or the ability of victims to seek a remedy. Now, why this matters to some extent is when we come to looking at the potential, very strong potential of EU regulation, is that the mandatory human rights and environmental due diligence requirement, which I fully support, should also include a judicial civil remedy and fewer obstacles. And I would say it's essential that the regulation itself sets out these remedies and doesn't just say, oh, it's up to each member state to determine for itself. Now, of course, there's always some degree of flexibility in relation to this, but my worry is if the regulation is too vague and member states then each determine their own form of remedy or their own form of determining whether there will be a remedy, you lose the important power of harmonised laws. And why is that important? Because in the study which Lisa and I and others did for the European Commission, it was very, very clear from the survey of over 650 companies and other organisations that there is huge support. I mean, it was almost 80% support from businesses for this kind of regulation. Why? Because they wanted harmonise a single harmonised form of regulation. And that breaks down if there's too many diversities amongst member states about what the actual form of means of determining it through liability, through civil remedy, if there's not coherence on that. So that would be one aspect. I would just finish maybe with one other point, which is the discussion of human rights due diligence with environmental due diligence, liability and judicial remedy is really crucial going forward, because we're in the early stages of discussion about whether there should be a business and human rights treaty, and there are varying views on that. But we're now at the stage, they've just been released last month, the latest draft of this treaty, which for better or worse, I'm meant to be a special advisor for. And that includes provisions on human rights and environmental due diligence, on liability, and on remedies. And putting the three together, I think, is quite important, rather than just saying it's mandatory human rights due diligence and ceasing it at that point. So I think there is a real sense to which, when we consider these issues of linkage of regulation on mandatory human rights and environmental due diligence, we do so in a way that acknowledges the essential and the vital element that there needs to be a remedy. Human rights due diligence, remember, is about prevention. But if we want a remedy for the victims, not just a remedy in terms of a fine or a criminal sanction against the company, then it's crucial that the two are linked. And I think the Lisa's papers are really good at recognizing how they can be linked. So thank you very much, Jonas.
Thanks a lot. Thanks a lot, Robert, and a lot of rich and wise comments there, and also some poesy with the water for the bouquet of flowers, remedies that I will borrow at some point. Thank you so much. So that is for now what we wanted to discuss or present in terms of human rights due diligence and related issues. We'll come back to that, of course, in the Q&A, but now we're switching or shifting slightly and moving to how private international law can contribute to improved access to remedy. I'm asking Ilaria, another member of our group, with a solid academic track record, just like Lisa, and working a lot on conflicts of law, and also worked on Remedy project, the big one that she was commissioned to be involved in fairly recently. So Ilaria, to you, how can rules on the choice of law help us unpack what the EU should do to improve access to remedy?
Well, yeah, thank you. Thank you for giving me this opportunity. And please allow me to first say how private international law has hindered access to remedy before talking about what we can do, because we have all seen how the mechanism of private international law that are often quite sophisticated have helped in the past, have served more the interest of multinational corporations of social dumping, and deprived de facto hundreds, thousands of victims of human rights violations, including the right to life, from having an effective access to remedy. So the enemy number one, let's say, was, of course, forum non-convenience, has been forum non-convenience, but also other mechanisms of choice of law have appeared to be an obstacle to human rights due diligence. Robert just mentioned the lex loci damni, the fact that often victims are obliged to rely on the law and the forum of the place where the damage occurred, which is sometimes the reasons why the companies have been going in that place. So other doctrines include the double actionability rule, the inadmissibility of extraterritorial jurisdiction, just to mention some. And I don't need to recall that American conflicts revolution has already displayed that maybe private international law is one of the fields where the Latin brocard summum ius summa iniuria applies best. So let me go from theory to practice and go back to Bhopal, 1984. During the cleaning of pipes, there is a leaking of toxic gas. And according to governmental numbers, 5,000 people died. Amnesty International talks about 7,000 people dying immediately, another 15,000 people dying in the aftermath, and 100,000 people suffering from chronic disease. As you know, in that case, American courts denied their jurisdiction on grounds of forum non-convenience, and then negotiated an agreement which doesn't cover not even medical care, not even the medical care. And the litigation is going on even now. The accident is 1984, and there were even recent decisions. So this is what we don't want to happen anymore. And more recent European decision raise hope that this is not going to happen anymore. And of course, I refer to the April 2019 UK Supreme Court decision in Vedanta, and to the Kiobel versus Shell decided by the Hague Rechtbank in May, the next month. So these cases are really of paramount importance, not only for the European legal framework in human rights due diligence, but also they are crucial for the European area of freedom, justice, and security, because it is self-evident to me and to all of us that the lack of corporate accountability for acts committed outside the EU by EU-based companies undermine the credibility of this area. So, as you know, different routes, different ways, different paths have been sought in order to overcome obstacles to access to remedy. And one of the already recalled one is the promotion of a universal recognition of a forum necessitatis. However, in the discussions carried out with Robert Bray, which co-authors with me the private international law report, we have not find arguments for an imperative necessity to promote the forum necessitatis in Europe. So we are not convinced that this forum necessitatis, the fact that Europe could dispose of a forum necessitatis, is a conditio sine qua non to improve access to human rights, to an effective remedy. Personally, I was talking about this with Katrina yesterday. I also think that the remedy could be worsen the disease in Europe, because I have studied civil procedure in Italy, a country who has an aversion against any scar to rigorous predictability of the judge. Besides, the promotion of forum necessitatis would require costly legislative reforms, and I see little enthusiasm now for a Brussels 1/3 regulation. So we have been concentrating and focusing, rather than in the forum necessitatis, to what can be done now with the present legislation, which is already conspicuous and already recast. So if the company caused human rights violation abroad is responsible for it, whether directly, as in Kiobel, because in Kiobel there was a direct responsibility of the parent company, or indirectly, if the company is based in Europe, we already have Article 2. There is already, Article 2 of Brussels 1 suffices to anchor litigation in the EU. And this was explicitly admitted in Owusu, who excluded forum non-convenience because of this reason. So this is a good example of the extraterritorial reach of these rules. And this solution is available today whenever a tort is caused abroad by acts and omissions occurred in countries with poor or inefficient human rights protection that is attributable to a multinational corporation based in the EU. So jurisdiction doesn't look as an obstacle difficult to overcome in the present scenario. When seeking a forum in the EU, the non-EU victims of human rights violation, however, they are also looking for a law guaranteeing a fair compensation, a better law than the lex loci damni. So I will not indulge now in this time frame in the characterization of the violation of human rights violation, but let me take it for granted that in most cases it is a tort of negligence, and we have to look at the Rome II regulation. So in this respect, if the jurisdictional issue may find a moderately satisfactory solution in the present framework, legal framework, less satisfactory is the legislation enforces regard the applicable law, because the only rule in Rome 2 that admits favor lesi, so that opens the door to the victim and allows the victim to choose the law guaranteeing a better protection, is Article 7 on environmental damages, which is interesting, because as Robert recalled, most of the cases, most of litigation on human rights due diligence starts with the pollution of the environment, and afterwards come the violation of human rights, like as in Cuba, as in Vedanta. So why the Rome 2 regulation is only respecting favor lesi in Article 7? It's because the EU often codifies case law of the Court of Justice of the European Union. And that brings us back again in the past to the Mine de Potasse d'Alsace case, which is a case where there was the pollution of the River Rhine, if you recall. And that case opened the door to the law of the place where the conduct causing harm took place. The decision taken in the headquarters of the parent company, for example. So what we need, and I will conclude on this note, what we need now is a Mine de Potasse d'Alsace extended to all human rights violations and not only to environmental damage. So thank you very much for your attention.
Thanks a lot, Ilaria. Also from you, a very rich and helpful overview, staying on the topic, but leaving again the project team member and going to Catherine Kessé-Dijon, which I'm very happy that we have with us here today, just like Robert, bringing an outside perspective to the discussion, and just like Robert, bringing a wealth of experience and insight. Catherine has practiced private international law, served in a senior post for the Hague Conference on Private international law, and is teaching the topic as we speak almost. So on this basis, Catherine, what advice could you share in terms of what the EU could do, again, to improve access to remedy, please?
Thank you, Jonas. It's a pleasure to be with you all. I hope you give me the rest of the morning to give you my little one penny thoughts on this. I am very happy that the European Law Institute is taking on this topic, and we need a lot more work, thoughts, discussions for the EU to be really a leading force on those topics. I have been really sad to see that the European Union was very reluctant at the very beginning of the UN discussions. And now it seems to be slightly changing, which I'm happy to see. But we absolutely need to be at the forefront of reform on those topics. I could second everything that Robert has said, so I'm not going to insist too much. But what I would like to say is it is very important to include, not to think in terms of one remedy against the other, one possibility against the other, but we need to have a holistic approach of what we need to have a balanced regulation, both for victims and for the tortfeasor. I'm speaking of a tortfeasor because I fully agree that we need to include not only private corporations, but also public bodies. And therefore, and that is in line with EU law. I mean, EU law has never made a difference between, if you have one activity that is made by a public body or a private company, normally EU law applies to both equally. I would perhaps what I would like to do at the very beginning is give you the archetype set of circumstances with which we have trouble right now in practice to get efficient remedy for victims of human rights violation. And I'm not so keen on saying severe human rights violation, but as soon as you start saying that, you plead for 2 years about what is a severe and what is not a severe violation. So I would stay away from too much characterization and too much differentiation at very first. The archetype problem is that you have a value chain. That's the concept that we are using now with globalization. So we have a value chain. Within the value chain, we may have contract law at stake, tort law at stake, but we also can have company law at stake. And that complicates very much the private international law thinking, because in private international law, we have been thinking in terms, and an applicable law and court jurisdiction is not the same, whether you speak of company law, you speak of tort, and you speak of contract. So I think the main reform that private international law specialists must be thinking about is how to kind of have a system that forgets about those silos, but is able to actually bring every single case within one set of rules that could apply equally, whether we are looking at the question through company law, through tort law, or through contract law. Because right now, EU law is a nightmare because you have Rome 1, Rome 2, Brussels 1, bis ter, whatever. I mean, it's ridiculous. So this is the main, I think, the main message that I would like us to stay with when we are dealing with those issues. And by the way, the GDIP, the Groupe Européen de Droit International Privé, is also working on this. And Hans van Loon has been very active on this. So there will be more work, and we should coordinate our efforts together. So if you take the value chain, you have activities by several different actors. And for the victim, it's absolutely almost impossible to actually find out at an early stage who in the value chain has acted. So if you are asking a victim to go to the proper court, and when I say to the proper court, it is the court which has jurisdiction according to Brussels 1, and I stay within Europe, okay? They don't know who in the value chain exactly acted, and they cannot know, and we should not ask them to prove that in order to find the proper court. So what I am saying is, all the discussions on duty of care, it's not on the court jurisdiction that we should make it. The only proper way to go about facilitating the victim's duty to find the proper court is the plurality of defendants. This is Article 8.1 of Brussels 1, and we have it. We may actually discuss whether it's properly worded for human rights violations, but we have the rule right now. And it's Article 2, of course, because it is linked with Article 2. But what we need to discuss is whether we must open a kind of jurisdiction which is provided by 8.1 of Brussels 1 further than Article 2. So I, for one, have been advocating that you need an Article 8.1 type of jurisdiction also for connected claims. So the article on connected claims should not be an exception, but should be a proper jurisdictional rule. So the reform, I think, on jurisdiction lies there. And we need to continue discussing this. And I'm sorry to say that the discussions so far have not been enough, in my view, on this issue. My second point, and please, Jonas, tell me, show me a sign if I'm speaking too much.
3 more minutes, please.
The second issue on jurisdiction that I would like to mention, and Ilaria, we had this discussion yesterday, and I said, ELI should have a full seminar on forum necessitatis. Do we need it? Particularly after the Knight-Lehman decision, which is a nightmare. I mean, I don't understand how the Court of Human Rights, for God's sake, in Strasbourg, was able to render a decision like Knight-Lehman. I mean, perhaps it was not the proper case. It was a poor case, perhaps. But still, I mean, we see in such decisions things that we should not see from the Court of Human Rights. It's impossible. So I continue to say that we need a forum necessitatis, but it is a last recourse. It is a last recourse. We should not think of forum necessitatis as, the thing that will be used every day. No. It must be there. It must be in the books, because it is now important to actually bring defendants which are not within the EU together with defendants who are in the EU before the proper court. So we need a forum necessitatis rules. And even though the Italians may have a little bit of difficulties with that, we will try to make it easy for you guys. My last point is on applicable law. I heard that perhaps a slight difference between what Robert said and what I'm going to say. I heard what Robert said about Article 17 of Rome 2, which is the excuse, because it's written like this, the excuse that a company or a public body, I mean, the tortfeasor basically, can take because they say, we have respected all the rules, and therefore you cannot put any responsibility or liability on our shoulders. I agree that this is a good rule in most cases, perhaps in the classic, in the classic tort, I have produced a car, I have done everything according to the regulation. But human rights violation is not a car production. So the rule of Article 17, even though I agree that it is a good rule in general, I think it has its really adverse consequences in human rights violations. So I would like to see a reverse Article 17. In other words, I would like to see an Article 17 saying, well, look, you are at the head of the value chain. And I'm speaking here to the EU parent corporation. You are the head of the value chain. You must make sure, and this is linked with the due diligence issue, you must make sure that every single actor within the value chain is respecting the highest standards. Why is it that an EU corporation is doing outside the EU what they would not be allowed to do within the EU? That's the real question we have to ask. And I think if you ask that question, then the answer is evidently no, they should not be allowed. And the way not to allow them to do that, it's not only the due diligence, it's good to have due diligence, but it's not enough, is to have the kind of liability that you could have if you have a reverse, what I call a reverse Article 17 of Rome 2. So I'll stop here. There would be other things to say about perhaps one issue for those of you who read French. Valérie Pironnon, a young colleague of mine from Nantes, gave us at the Comité Français de Droit International Privé a very, very thorough analysis And she disagrees with relying on public policy for a very interesting reason that I don't have the time to go through, but I would encourage you to read her piece. Thank you very much.
Thanks so much, Catherine. And a fourth very rich and helpful overview, and I think you nicely added to the picture that Robert drew in my head with this bouquet, elaborating on some of the flowers that somehow some of them should be turned upside down in the bouquet maybe, or replaced, or whatever the solution might be. I think we have a very good solid basis now for a discussion, and luckily I'm moderating only, so I don't have to answer the good and complicated question that already came in. And if you look there on the tab under Q&A, there are 2 questions. So if I would read them out and then ask anyone who would like to address them to do so succinctly and as much in detail as possible. So from Adrian Ward, how does the project team envisage ensuring that all remedies and ancillary rights to ensure access to them are fully available to everyone, especially those with greatest support needs? In fact, and not only in theory and including cross-border situations. While you think of something clever to say, I could, of course, say superficially that the project team would not even have that ambition. Our ambition is to advise through this project, eventually the European Union, on what could be done to improve the situation. To have the nice situation that you suggest would be indeed desirable, but we're not that ambitious maybe. But maybe Lise or Ilaria in particular, but Robert and Catherine, of course, also most welcome. I think Lise is smiling more than the others, or is that a no smile? I think that's a no. No, please, Lise.
Jonas, I was actually looking at the second question, which I thought, I don't know if you want to read that one out as well. I think that is...
Or you read it and answer it. That would be fantastic.
Oh my goodness, okay. Oh, sorry, now I've so closed myself here. Basically, the question is just really about, which is something we also saw with our European Commission study. It says, as we've seen from practice, similarly as with non-financial reporting, due diligence requirements in certain sectors were quite misunderstood by the businesses as mere reporting obligation and did not significantly improve the situation of human rights. The reasons are many: complexity, lack of human rights expertise within business and others. In the context of upcoming plans of the European Commission to issue mandatory legislation on due diligence next year, how do you think setbacks of due diligence requirements should be addressed in the new European legislation? Any specific role for lawyers? Thank you, ELI member from Lithuania. Thank you so much for this question. I mean, if I may just start here, I think it's certainly something that we haven't addressed here, but it's something we look at a little bit in this chapter, but it looked in a big way in the European Commission study, which we did, the difference between reporting and human rights due diligence as a standard of care. And so if I may just take a step back to the European Commission study, as Robert said, there was a survey of over 630 respondents, and there was 50 interviews and various other empirical research factors there. And we had 4 different regulatory options, of which mandatory human rights due diligence as a standard of care was the 4th, but new reporting requirements was the 3rd. And so we had that opportunity to contrast people's views on reporting requirements and due diligence requirements. And it also became clear that there is a misunderstanding. There is often people speak about due diligence. They mean what we understand from the business context as a once-off sort of process that you do pre-transactional, you have a due diligence done, and it's something that you can put in the drawer and you hope to whip out when something bad happens as protection. And so what we've seen in other areas of law, such as corruption, is that this piece of paper is not enough. What the court or the regulators in corruption cases will usually do is actually say, well, what did you actually do? So first of all, let's look at your process, and that's the same in tort. And in other statutory instruments where due diligence is a defense. So let's look at your process, but then also let's evaluate the process based on reasonableness for the circumstances. Is this process even on the face of it enough to meet the risks? And then also in practice, did you actually do what you said you were doing? Who picked up the phone? Who has the resources? Who is on the ground? Factual inquiries, which a court would need to look into as a matter of a factual test. So reporting requirements and due diligence often confused, which made it very difficult to do a study on this. Also, because people cannot, you cannot expect people to have views on a regulation which there's so few examples of in practice at the moment. So that's one of the reasons why it was an initial study. It was a challenge to do, but we have other examples of due diligence as a standard of care in other areas of law, which I'm hoping we could draw on. And then the last point here is just in terms of, if you look at reporting requirements, we see them as they would become eventually complementary to a due diligence process, because if you have a duty, a legal duty, then it will automatically come within the realm of the reporting requirement to report on steps taken to meet such a legal duty. A lot of the confusion has been existing in existing reporting frameworks as to what is material, even social environmental materiality. It's not clear. So we're hoping that the clarification of the law will also provide more central answers to what falls within the materiality question. I don't know, it's a big question, which I'm hoping I just touched upon that, but thank you so much.
Yeah,
thanks a lot, Lisa. And please,
a couple of quick points from, I agree entirely with what Lisa has said. I want to clarify that sometimes businesses support much more clarity in this and not just reporting. It was interesting, for example, just a few days ago, 26 businesses, large businesses, supported an EU regulation, which is proper regulation, not just reporting. And I think we often think business is opposed to it, when I don't think that's the case. In fact, the reason the Australian Modern Slavery Act came into force so quickly was because businesses as a whole supported it. And so it was a coalition really between business and the NGOs, which rapidly made it into law. So they want this kind of clarity. The other element of that is, of course, there is a role for lawyers. I think the question included that within the European Commission when drafting this. And I think I would really encourage them to bring on lawyers who know this area. You just look at the extraordinary clarity and intelligence and insights that Catherine has just provided. That's not there. They don't, not surprisingly, have that degree of thoughtfulness that she brought. But I want to pick up then on something which connects with a very interesting point about the kind of Article 17 approach. One of the ways that I think this could be taken up is to slightly change where due diligence fits, which is that there could be what's often called a failure to prevent obligation. And if there's a failure to prevent on the kind of companies which Catherine was talking about, such as in the parent company, if they have that obligation, it changes the onus, it changes the expectation, and as part of their failure to prevent, they have to do human rights due diligence, which is, I think, quite an interesting way. And it's come into, for example, the Business and Human Rights draft treaty. I think it's Article 8.7. So I think that's another way of maybe bringing together some of what Catherine's saying and change that expectation. I just wanted to make one other response to the question, which was about well, what do we do of this in relation to getting a remedy? Sadly enough, the better place for most victims is going to be in the place where the damage occurred. But too often there's not a rule of law there. There is no means of actually getting a remedy within a reasonable time. And that's why we end up in European courts. So of course, a great thing would be to do some capacity building within those courts in the location. But I think, as I think Lisa made the point, the reason companies are often there is because they know there isn't that kind of rule of law operation. So it's a tricky thing. And we look, for example, at a different area of law, international investment law, where time and time again we see companies in one argument might be saying the Vedanta, oh no, it should be decided in Zambia. But then if Zambia tries to introduce the law and say, no, this is contrary to international investment law, we're going to take you to an international court or arbitration. So we have to recognize that there are different pressures here, which mean that it's necessary to try and capacity build within where the damages have occurred. But the reality is, sadly enough, for some time yet, Europe is going to be the place where some of these developments are going to occur. Thank you. Thanks a lot, Robert. The list of questions are growing, but thanks for those responses, and thanks, Lyra, for your elaboration. You also mentioned the non-financial reporting and the crudeness of that and the insufficient detail and on the reporting, and just reminds me that as soon as this meeting is over, I will switch meeting and join an EU, just starting today, an EU advisory body that will elaborate details on the non-financial reporting directive. There's a similar thing for the EU taxonomy regulation that I'm also involved in that will start in a few weeks as well. So at least slowly the EU is trying to come up with more details, more guidance on how companies better can deliver details. And I guess that will relate very much to the human rights due diligence approach later on as well. There is a follow-up in one of the questions here from Adrian. Should there not be an obligation on any court that declines jurisdiction to determine which court does appear to cooperate with that other court to establish whether it agrees and to transfer the case to that court? Would that be something? Maybe a quick answer from anyone?
No decline of jurisdiction, not allowed.
So you'd have to deal with the case.
Yeah.
Okay.
And they can cooperate. I mean, everybody who has heard me before know that I am the big fan of cooperation between courts, so I won't go into that. But they can cooperate between courts. But declining of jurisdiction, it's another 2 years of discussion between parties, and I want to simplify the litigation for everybody. It's not only for the victims. The defendants also need to have less litigation. It's not good to have litigation anyway. May I tackle? There are 3 questions that I saw in the Q&A. But before I do that, Robert, we have to continue working on the investment side. You touched upon a very, very difficult issue. Now, and the Dutch model treaty is actually a very good example. We have now incorporated more and more human rights and CSR obligations for the investor. And then what exactly the consequences, if there are violations, is still really very much in discussion. But there is a little bit of movement on this. But again, I was speaking of silos. That's another silo. You know, the investment people are in one side and the human rights people or business and human rights are on the other side. So we need to work on this. Now, on the 3 questions that I saw, first, Rhoda, sorry, I'm probably not pronouncing your name correctly. You are a PhD student, so I'm going to be very careful because you know certainly more than I do. The divergence that you are actually pointing out in your question is really a consequence of the non-harmonization at EU level of the question of joining a plurality of defendants or a plurality of connected claims for outside of the EU defendants. It is because the EU law does not say anything about that, because the Brussels one only speaks about defendants that are within the EU, that you have different national law apply. So I am for one advocating an EU harmonized rule on joining non-EU defendants so that we will have a harmonized system within the EU. And by the way, I read Vedanta as much more narrow than what it has been said before. Vedanta is almost a forum necessitatis case. If you look at what really was the decision, I mean, the Vedanta is a very long decision, and the court went on and on with duty of care, etc. But it didn't use duty of care in its decision on jurisdiction. So it's a very narrow. So we still need some more developments on this. Now, there was another question about forum necessitatis. This is Claire Bright. You are absolutely right. If we have rules such as the ones that I mentioned in my main presentation, we may not need forum necessitatis, but you know, there are many, many rules on books that are never used, but it's better that they are there in case we need them once. So I'm still saying we need forum necessitatis. We may not use it, fine. And in fact, we may actually develop arbitration and mediation in such a way that, and the NCPs in such a way that we may not need courts so much. But right now, the system is not developed, so we still need courts. And Pascal Pichonaz, I think Pascal, and to your defense, Pascal, you are not a private international law specialist. So you have to divide, and that's the problem with private international law. We have to divide applicable law, substantive law, and jurisdiction. So I think in your question, there is a little bit of a mix in it's not because you access court that you will have a remedy. That's why due diligence is essential, because due diligence is helping framing the substance of a remedy. In terms of access to court, you only need a vraisemblance of a case. But you don't need to prove that you have a case. If not, courts would be of no use. So I think that's the issue that I see in your question. I'm probably not fair to your question, but if you want to ask more, I'm ready to try to answer better.
Maybe Ilaria, anything to add from your side?
Yes, please. Thank you. Thank you very much. Yes, so I wanted to clarify, because I don't know how much our public, as Catherine was pointing out, is aware of the mechanism. Of course, and also I would like to take the chance that Rodrigo Rodriguez is giving us. So in fact, Kiobel did indulge on the plurality of defendant and joinder of action. But what happens is that we have Article 2 of Brussels 1 bis that allows us to anchor jurisdiction in Europe. And then we are trying to use Article 8 in order to have jurisdiction also over the subsidiaries that are not based in Europe. But the problem is, as Catherine was saying, that we don't have jurisdiction over those subsidiaries. So we have to ground that jurisdiction on national law, as far as it is now, because as we have already said, we don't have harmonized solution for extra European disputes. Let's call them so. So before there is, at the present state of affairs, we are only seeking, and our report is focusing on the liability, on the accountability of parent companies that are based in Europe. And in this framework, we do not really need a forum necessitatis in this respect. So, for instance, we could also admit, let us admit a forum necessitatis in a case where there is a Chinese company, a parent Chinese company, who is carrying out human rights violation in Africa. We can even anchor jurisdiction in Europe and grant a remedy in Europe to the victims. But then we will have to enforce this judgment in China. So it's going to be unlikely, and maybe it's also in violation of the principle of procedural economy that we grant such a remedy in Europe when we cannot enforce it. So we are really, our paper is really considering merely the case of a European parent company which renders herself liable. So this is a first step. Of course, we can go further. We don't want human rights violation to take place nowhere, but our focus is now on what Europe can do for European entities, entities that Europe controls, public bodies also, and for acts committed abroad. Thank you.
Thanks a lot. We have a question from Christopher Patz on residual jurisdiction. Is that anything any of the panelists would like to address? So specifically, the question reads, is there any prospect of so-called residual jurisdiction to allow for bringing non-EU companies before EU courts?
I guess I did already answer to this question, but I want to rebound on that only for because somebody talked about the transfer of jurisdiction. I fully agree with Catherine. I'm more in favor of cooperation, and we did a study for the European Parliament where we wanted to change actual, because in Brussels 2, we have an Article 13, and before another, which allows a transfer of jurisdiction. So if a European court considers that another European court is more apt to discuss, to litigation, to decide litigation, they can transfer. But we had thought, and we were also in favor of the two courts cooperating, because especially in family cases, I've been studying child abductions, the two courts need to, we have seen that it's essential that the two courts cooperate because they have two different visions, and one court may have a biased vision. We have to recognize this. So it's not the case, because actually it's not the case now at present, but it should be. We should move in that direction of cooperation between courts. I agree with Catherine. Thank you.
Thank you very much. Lisa, anything from your side? We have a few minutes left, and any of the questions or anything you would like to add? It's so nice to hear your South African accent, so I'm just asking you to speak for that reason.
Thanks, Jonas. No, I mean, I think this is all really, really interesting. I just wanted to come back to the question which Robert mentioned as well about the support for mandatory human rights intelligence obligations from business, and actually the findings that companies do not support the idea of burdensome tick box or reporting requirements, and so there's often an understanding that reporting is sort of a due diligence light, because you don't have to do the due diligence, you just have to sort of report, but it's actually, these are two extremely different models of regulation, and reporting requires very different things than a duty of care. Reporting is onerous. It usually superimposes on the company which issues it has to report on, even if those are not the ones that are the most salient risks. And it also has a disproportionate effect on smaller companies, because if you have to produce a 30-page report as you're a large multinational, it's not the same if you're an SME. So I think, whereas a duty of care, it's something that we know from tort law, it's something that we understand. And again, I also just wanted to I agree with Catherine about the with the Vedanta case and the case that we've seen so far. The issue there is just to get into the court building. That's what that fight was about. But whereas what we're going to see now, hopefully, if we have a mandatory duty, is the doors going to be once you're in the court, if you can get in, that's what the discussion will be about. We don't really know yet how Vedanta and these other negligence claims would have panned out, because they frequently either fail at the court doors, or it's jurisdictional, or they are settled once it gets to the merits. So we don't have a lot of precedent there, and so the core of the duty is what we don't really know yet, what that will look like on the existing tort law, and that's what we really want to get to when we have a duty, because that will be hopefully then a lot more of a solid, when claimants have to assess their risks as to whether they should bring a claim or not, they will have a law that they can rely on. And the flip side is also obviously for companies, is they will have a standard that they know what the law requires them to do, which they don't currently have.
Thank you so much, Lisa. And I think we've roughly addressed all the questions to some extent, at least. We have, as it happens, 4 more minutes, and we have 4 panelists. So now I would like to challenge you and just give, if you had one piece of advice for the European Union on what to do, which flower to invest in, and it would only be that one flower, or it could be the water for the flowers, but one remedy, where would you put your energy? Where should the European Union invest its focus? And maybe we start in reversed order. So Catherine, Ilaria, Robert, please.
I'm sorry, I'm not going to go your route. I'm going to say not only you need the water, but you need the stems, you need the seeds, you need everything. And we really need to focus on all those issues and make that a holistic approach. I'm still sticking to my initial idea, sorry.
So a big nice bouquet. That's okay. Ilaria, which flower would you bet on?
I also like the bouquet as a whole. So, but what I would like maybe to point out is that the European Union has been really, really fast in building a very sophisticated legislation on jurisdiction, on private international law, and it is now going for a code. We are talking about the Code of Private International Law. So maybe it's not the legislation which is lacking and which is imperfect and to address. Sometimes I have the feeling that all this investment on recasting rules that are already quite flexible and can be used. It's sometimes only a matter of the right interpretation. And the Court of Justice, of course, doing a great work on this, but the Court of Justice works only on topics that are addressed to her. So it cannot have that holistic approach that Catherine was mentioning. So just to finish, maybe, the focus should also be in studying how in practice, what in practice is needed and how our rules, which are already quite perfect, can address the practical needs. So further studies.
Thank you. Thanks a lot, Ilaria. Robert, please.
Firstly, I don't take credit for the phrase bouquet of remedies at Soraya Diva and the UN Working Group on Business and Human Rights, for which I criticize him, I have to say, because for most people, flowers are a luxury. And if you're a victim in a developing country, flowers are nowhere near, and the most you might get are dead ones. So I think that's why I think concentrate on the water. And the water is actually essential for life as it is for flowers. That's why I'm turning it around a little bit. And I completely agree, as always, with the comments by Catherine, because for each victim, the issue which is going to be important to them will be important to them. We can't decide. That's like determining a ranking of human rights, which we cannot do. So I think I wouldn't want to choose for anyone, but I would want to say there has to be water. And I like the notion, Catherine was talking about silos. The water has to be mixed, because the idea of business and human rights is not some neat separate area of law. It interweaves a great number of areas of law. And I just want to add to that, we've seen with COVID, which we haven't discussed, that just how deeply damaging some of the existing value chains are. That when a company in Europe decides it's just going to slice off its supply chain because they're worried about their underlying profit, for the people in Bangladesh or Vietnam or wherever that is, they have no furlough, they have no backup, they have no healthcare, and so the consequences are really severe on them. And it'll be interesting to me where we go in terms of what that might mean. But if we had a really strong mandatory human rights environmental due diligence with clear liability and remedy, then actually it begins to change what companies do and the resilience of their broader value chain. So I think now is absolutely the right time to begin bringing this in.
Thank you very much. Thanks, Robert. Lisa, if anything, very briefly, please.
Yes, I just wanted to flag that I recently heard learned the German terms, which is that due diligence is not an Erfolgspflicht, which is a duty of success, but it's a Bemühungspflicht, which is a duty of effort. And I think these terms are really good in describing it, and for us to remember that this is the nature of due diligence. It's not a strict liability. It's not the idea that you should hide any existing human rights violations, but for us to ask what are companies doing and how can we hold them accountable to that instead. Thank you.
Thank you very much, and great German there. Next time we'll do some Swedish vocabulary training. That will be even better. I would like to thank all of you, the 4 panelists, and I understand there were quite many participating in this webinar, listening in, asking questions, and of course, again, to the ELI Secretariat. And if I would allow myself a summary, I think we've talked about a number of remedies that could be improved, the interrelation between remedies, the need for clarity for victims of human rights abuse. And I think we shifted a little bit from what I thought was a very nice picture, but I understand the criticism of the bouquet, to more of a silo. And I see in front of me a concrete silo, which is less beautiful, but I think we're looking at some kind of a mesh system of functioning mechanisms that interact and interrelate. Thank you very, very much, and all the best, and have a good weekend.